Okay, looks like we're live. Good morning, everyone. This is PodShoot, another special edition of Fine Points, which is going to be our regular weekly series of discussions with Bruce Fein, who is an esteemed constitutional scholar, lawyer, and author. But Bruce has been doing extra double, triple, quadruple duty lately, speaking to me pretty much every day that the court has been dropping opinions. This is the last day, probably the most important day. And I guess, Bruce, you are saying it's the most disastrous day. Is that correct?
Since Dred Scott versus Sanford, I think that it's a case called Trump versus United States. It's over 100 pages long. All the three cases today are like 300 pages, so they wrote a lot. I don't think they had to write a lot when it comes to knowing that the rule of law is king. The king is not law, but that's not true anymore. The gist of the opinion in the Trump case was authored by the Chief Justice John Roberts. It was 6-3. The three dissenters were the typical liberal side: Kagan, Sotomayor, and Jackson. The six were the regular six. But the court declared, without able to summon even one word in the text of the Constitution, that a president, even after leaving office, is absolutely immune from criminal prosecution for executing or purporting to be pursuing his constitutional powers. For instance, faithfully executing the law. Now, let me just pause for a moment, Amy, to string out what that could mean. One of the laws we have is the Insurrection Act, which the president can utilize to summon the military to enforce the law. And he can arguably say, there's martial law now, saying, I'm faithfully executing the laws. Arrest all of his opponents, stick them in prison, and say, I'm immune. Because that's the core presidential function, is to faithfully execute the laws, even if I do it for a corrupt reason. And what is astonishing to me is that a court that is so, and I support this, preoccupied with looking at the text of the Constitution, not finding things in what in old times were called the penumbras and emanations we learned about in law school,
Yes.
That it finds this immunity, even though it's not in the constitutional text.
Now they said that there is a presumptive immunity, right? The way I understood the gist of the ruling was that there's
if it's non-constitutional core functions. So they divided presidential acts into three categories,
right.
Which again, it reminds me of the abortion decision, the trimester system, which was kind of invented by Harry Truman. There's nothing in the court, in the Constitution says there are these trimesters. Well, now there are three categories of presidential acts that are just summoned from thin air. Where's that in the Constitution, right? And they say there are core presidential acts that relate to discharging constitutional functions, like faithfully executing the laws, issuing pardons, things of that sort, that are absolutely immune. You can't use them in any respect in the criminal prosecution. Then there are official actions that are not necessarily constitutional, but are part of just what a president does. Maybe holding a press conference, something like that. They're presumptively protected, but if you can show a certain threshold of corruption in them, an improper motive, you can defeat the presumptive immunity.
Right.
And think about this again. I'm kind of thinking through this, and I apologize to the audience because it takes a while to digest 100 pages. With regard to core presidential functions, one of them we know is issuing a pardon, right? The president has pardon power. So under this theory of immunity, a president could take a bribe to issue a pardon and he's immune from criminal prosecution. because he's executing a presidential duty, right? Issuing a
Right.
pardon. I mean, that's it's unbelievable to me. And you could argue, well, but maybe the president could be impeached. Yeah, true enough. But we know, given the partisanship, if he controls either one house or the other, they'll never impeach him. It doesn't matter. As Donald Trump said, he committed murder on Times Square. Um, anyway, going back to the court's decision. So you have one category is absolute immunity for performing constitutional duties, then presumptive immunity for actions in the course of being president that aren't necessarily discharging an explicit constitutional power. And then you have private acts,
Right.
where here, I mean, for example, one of the elements of the indictment is saying Trump schemed with private parties to get fraudulent electors to represent that they were the true electors casting votes in favor of Trump rather than Biden when the January 6th counting began. And purely private acts are not immune from prosecution. But you can imagine, given the rather sprawling events on January 6th, including the speech and the lips, and then the march, and then the attack, and then Trump watching for 3 hours and doing nothing, and then issuing a statement saying, I love you, but, after all, kind of be nice to the police after you beat them over the head. It's going to be hair splitting. Which ones are official, which are unofficial, which are immune, which are not immune. So as a political matter, that means it's going to be virtually impossible to have the case tried before November. If Trump wins in November, then he will order the case dismissed.
Sure.
Against himself, even though you can argue it's a conflict of interest, but that's a presidential power, so he's immune. You can't challenge that, according to the Supreme Court. Even though it's hard to imagine a clearer case of a man being a judge in his own case, right? Which is supposed to be prohibited since 500 years ago in Dr. Bonham's case that we learned about in law school. In the English common law, a man can't be a judge in his own case, but now he is a judge in his own case. So that's where we are. I think that it's possible the prosecutor may go back and look at the indictment and say, if he wants to try to get the case alive before November, well, let's drop certain of the alley. Let's not debate whether this is official or unofficial. It take too much time. Some would clearly be unofficial if Trump is just talking to private parties with regard to the re-election and having nothing to do with his official duties. Now, to me, at least so far, because I haven't had a chance to digest the 103 pages as carefully as I will, the most stunning thing the Chief Justice said was in addressing the allegation in the indictment that Trump, on the morning of January 6th, summoned the Vice President, Mr. Pence, and demanded he choose between me, Mr. Trump, and the Constitution, and counting the electoral votes.
Mm-hmm.
Now, Amy, I've read the Constitution a lot of times. There is not a word that suggests a president has any constitutional role in counting electoral votes. Zero. So, but that, he says, the chief says that's presumptively protected presidential act.
Yeah, he has this weird phrase, and again, as you said earlier, you would talk about the penumbras and the emanations from the rights and the Bill of Rights and all that language that we learned in law school. He uses this phrase, outer perimeter of the president's official responsibilities. So if it falls within this outer perimeter of the president's official responsibilities, there is presumptive immunity. And as far as I understood, they divide the allegations into a few categories, but with each they say, we remand to the district court to conduct, the first level of review, a fact-specific analysis with respect to the principles we lay down here, blah, blah, blah. But as you say, I mean, you're saying essentially that you disagree with Roberts, that action by Trump is even arguably within the outer perimeter of the president's official responsibilities. Is that correct?
I don't think it's within any element. I think it's within nothing of the presidential responsibilities. Right. Just like it's not a presidential responsibility to go commit murder in Times Square. There's nothing in the Constitution that says that. It can't be clear if you just read the text and are not searching for penumbras and emanations, which makes you think this is a political decision. But, I'm not surprised. We live in an era where things are very polarized and result-oriented, and principles are like restricted railroad tickets, good for this day and train only. They come one time and then they fall away the next day. But I think that's an example. And then even the language, Amy, outer perimeter. Oh, so there's an outer and inner perimeter. How do you decide it? Do you calculate? Pi is, now we have a new formula, like calculating the circumference of a circle, right? Pi. You don't do 3.14159, but you move toward the outer circle only 2.37, and then you draw the line there. I mean, the whole thing.
Well, let me give you a counter argument that occurred to me. So I hate this sort of very pragmatist. I would call this an example of legal pragmatism, where you've got this very case specific analysis, and it's vague to figure out what is this outer perimeter, et cetera. And they send it back to the court and say, you do something with this, right? So I think that would be a terrible approach, and it is a terrible approach whenever they apply this to something as commonplace as a woman seeking to obtain an abortion from a doctor, right? Because this happens all the time. What about the fact, Bruce, that this is a once in a couple hundred years, this sort of case that happens? And maybe you could argue that this sort of very case by case analysis is necessary in something as sensitive as this, no?
Well, I think your argument, Amy, proves the opposite. That is, if it's 1 in 234 years, then why do you need to focus more than on the particular facts and danger presented by Mr. Trump? It hasn't happened 234 years. And they keep writing. Oh, we're not just writing for today. We're writing for the exigencies for the future. Why? Mm-hmm. Most of the time, you don't write for the exigencies for the future. And if you have a problem once every 234 years, that's really a good constitutional doctrine you have. To only raise a problem once every 2 centuries, hey, a country can live with that. And so, and moreover, there's no stopping point. Once you abandon, this is what the court says, once you abandon the text and you're just into pragmatism, well, what you may think it's pragmatic. I don't think it's pragmatic. If I am to just look at my view of pragmatism, I say, just as a matter of pragmatism, no, I want to deter the president from even getting close to illegality. I want him to be chilled in this exercise of constitutional duties, because I think most of what the government does is bad. So I want him to assert the power less rather than more, and therefore let's give no immunity to anything. That's my pragmatism.
And they did exactly the opposite, right? Because they said, not only does he need immunity for those official acts, right? He needs presumptive immunity for the stuff in this outer perimeter, so that he can feel, like he can just go ahead and do what he believes he needs to do, et cetera, be unrestrained.
See, and this really turns, the understanding of the United States on its head. That is, the Revolution and the Constitution made liberty the glory, not government power. And government power was not to be prohibited. Obviously, you have to use it because people engage in antisocial acts, murder, robbery, and other things like that. But there's a presumption against it because it preserves liberty. You get to march to your own drummer unless you're doing something that really is harming somebody else. And that's thought to be the glory of the United States. And now the court is saying, oh, the glory is, let's get the president really to push the very edge, to the very edge of his executive power, maybe even over the edge, because we want very aggressive executive action. Why do we want that?
No, yeah, you're right. We are supposed to be the country in which government operates only by permission and the people have the presumptive freedom.
Yes.
And this is saying no, the president himself needs to have presumptive immunity, even in actions that aren't his strictly official actions. And so it's government, having the ability to operate not by permission, not as a servant of we the people according to the rules laid out in the Constitution, but according to whatever he thinks is right at the time.
Yeah, that's correct.
Yeah.
And I say, and this is a broader, far broader than just this particular decision, Amy. But that's why I wrote in my book, American Empire Before the Fall. And I said, we've come full circle. That is, we wanted to divorce ourselves from the British Empire, where the king can do no wrong. The glory of Great Britain was, hey, we conquered all these other people. We treat them as slaves. We're rich. We're better than you. And we said that's no, because we were on the brunt. We were on the end point of that kind of arrogance, right? Because we're the colonists. So we get taxation without representation, no trial by jury, a lot of other things that we lost under the British Empire. And that's why we celebrated this idea of liberty, the right to be let alone, checks and balances, limited government, as a rejection of the British model. We don't want to be an empire. We can assert our influence abroad by example without any military arms whatsoever. We brought forth the French Revolution because of our ideas of government by the consent of the governed. That no, there is no divine right of kings, right? And we didn't have any artillery, we didn't have any navy, no ICBMs, nothing. And that was the idea. Now, I'm not going to be Pollyannish and say ideas automatically going to win abroad, but the fact is, if there wasn't any French Revolution, it wasn't going to affect our democracy at home anyway, right? We still had our ability to defend ourselves. We defeated the British, even though they had the biggest empire in the world at the time. Napoleon wasn't going to defeat us either, because we had a will and we had very, very high esprit that we wanted to be able to march drone drummers. And the jurisprudence of the time at the outset rejected all these claims of immunity and unheard of. Strict liability for president, executive officers, no immunity whatsoever. Immunity only came into the play once we began to become an empire, which was really with Woodrow Wilson, and then it really accelerated after World War II.
So you think that they got away with this sort of opinion only because it was an issue of first impression? So they thought, easily distinguish away the case of requesting evidence from the president, right, versus prosecuting the president. Is that what allowed them to do this? Or
well, I mean, I don't know. They were going to do what they're going to do anyway. Amy, this is a very unique case in the sense that all of the lower courts, and there are at least a half a dozen, including courts of appeals, had ruled against Mr. Trump across the board. There was no conflict anywhere, none. There wasn't even a conflict with the Office of Legal Counsel, which had twice opined, yeah, a sitting president can't be indicted, but a former president can.
right.
So where's the conflict? There's none. So, and as regards, it is certainly true that Mr. Trump is the first one that was actually indicted as a former president. But I can tell you, having been there present at the creation of Watergate, Richard Nixon took the pardon because he was going to be indicted.
Right.
For obstruction of justice, right? Now, the pardon then mooted the possibility of indictment, but it wasn't like it wasn't a front burner issue. It was. And nobody thought, oh my God, if that happens, the world will collapse or anything of that sort. In fact, it turned out to be a disaster for Gerald Ford to have issued the pardon, probably cost him the election against Jimmy Carter in 1976. So I just think it's the empire mentality thinking. And it may seem simplistic, but I think by and large it's very accurate. If you have an empire, you have to have a Caesar, right? Unity, secrecy, unity of command. You got to be able to just do whatever you want because you got to control the world. We're the indispensable nation. Okay, then you got to have a monarch. I mean, that's what happened Amy, in the Roman Republic to descend into an empire. The Senate would confer upon the warrior, Caesar or Pompey, limitless power. Scipio Africanus. Okay, for an indefinite period, you have all the power you want. You're the dictator. Go forward and fight wars. And of course, then they came back and said, "Why do we need to give the power back? It's ours." And they bring back loot and whatever that would enrich at least temporarily the Roman people. They'd have bread and circuses, and then they accepted this. But that's that, and since because I think for ill, but we clearly have chosen empire over liberty. That you got to give the president limitless power. And that's why.
So the court would say we didn't give him limitless power. We're just giving him a presumption of immunity. Are you, in stating it that way, focusing on the fact that, practically speaking, right now, going back and litigating that presumption and whether it applies in the different factual contexts and the allegations is going to take so much time that Trump could win and then he's going to pardon himself and he's going to get off scot-free practically? But they're saying, the court is saying, we're not going to give him completely free reign. We're not giving him everything he asked for. We're giving him absolute immunity only with respect to this narrow category of official acts. And then with the outer perimeter of whatever, right? We're giving him this presumption.
Well, I think, Amy, from what you said, that's accurate, but I'd say incomplete. It's incomplete because there is another category of acts which says are absolutely immune when he's discharging a core constitutional function. Take the war power. Suppose the president says, I can declare war on my own. I'm declaring war on the Republican Party. I'm declaring war on the Democratic Party. I'm declaring war on whoever he wants, right? And he could send off, and he said, and because it's wartime, I'm going to do conscription on my own, whether there's a congressional statute, because it's inherent power if you're going to fight wars. That's absolutely immune. You couldn't do anything to the president for that, because he claimed, war powers.
You don't think with respect to some of those concretes, you could bifurcate the part that is actually an official action that is authorized by the Constitution from the part of it or the aspect of it that is not?
No, because then the court didn't do that. And that's why I was trying to explain. And the court says, okay, if you issue a pardon, that's clearly a constitutional act. The president has pardon power. Now, it's said, although I think wrongly, the president has power to go to war. Okay. You think he's doing it improperly, but in generically, okay, that's the war power. The things that are presumptively protected with things like holding a press conference. Well, that's not in the Constitution, right? He doesn't have to hold press conferences.
Right.
Then he could make a speech, in favor of or against certain legislation. He doesn't have to do that. So those are non-core constitutional duties. But when you come to and they say the one that is most frightening, a core constitutional Article 2, Section 3 is to take care that the laws be faithfully executed. So he could say, hey, I'm just executing the Insurrection Act. I'm going to lock up all my opponents. I think they're really clear and present danger to the United States. Now, you may think that I made a wrong judgment and I misinterpreted the Insurrection Act, but so what? I did. And that's a core constitutional duty, is to take care that the laws be faithfully executed, and you can't second guess me. That's the most frightening aspect of this all. Because the president can always say, yeah, I'm faithfully executing the law because this is how I interpret it.
So how would you have adjudicated this case? What would you have?
There are two things. Amy, number one, I would never taken the case. I just affirmed, I said, listen, the court got it right below in the Court of Appeal, which is not code pink. It's a very balanced court, got a lot of Trump appointees and others, and just said there's no immunity, period. And this is the view of the Office of Legal Counsel, issued when I was there, that once a president leaves office, there is no immunity whatsoever for criminal prosecution. After all, you still have to prove the crime. It's not like, okay, there's presidential acts, then you're guilty, you go to prison. You have all the presumptions of innocence, proof beyond a reason without cross-examination. You still have to prove the elements of the crime. But why isn't that clearly placing the president above the law if after he leaves office, if he committed crimes, as a president, that he can't be prosecuted. Let's go back, for example, Amy, to Nixon's case. You remember that one of the key pieces of evidence that provoked first the impeachment vote in the House and then his resignation was that he was caught on tape as president, telling H.R. Haldeman that to the grand jury, hey, you can just say you don't remember, cover up, and lie, right? Mm-hmm. He's conspiring to tamper with a witness, commit evidence.
Kind of stuff that Fauci was guilty of. Yeah, go ahead.
Yeah. So what he could, under this theory, no, you couldn't have indicted. He'd say, I'm trying to execute the law of grand jury investigation. And he's my chief of staff. I'm just trying to help him, to make sure that the investigation goes the right way. So
you think that's how it's going to be applied? Yeah. Oh, okay.
I say this, Amy, that the court, it doesn't write in Euclidean geometry with that level of clarity, like outer perimeter, inner perimeter, whatever. Mm-hmm. It's surely going to raise cases that will make it as a practical matter almost impossible to prosecute. Because if you have the president involved or a former president, the Supreme Court virtually always takes the case, like they did in this instance. Mm-hmm. So, all right, you're at the trial court, then you go to the Court of Appeals, and because it's an immunity issue, you don't have to go to trial first. All the immunity issues have to be decided before you go to trial. So you go up to the Court of Appeals, then you go up to the Supreme Court. It'll be years. You might even be dead by that point.
Well, what if, again, it's remanded to the district court to figure out this presumptive immunity and how it would apply. Suppose the court does what normally isn't done and turns this around very quickly. And
it'll go up on appeal.
Sure, it'll go up on appeal. I know. And then suppose everybody's doing everything expeditiously. It could still play out before November, could it not?
No, they go up to the U.S. Supreme Court again.
And they're just going to take their time. Okay.
There's just no way. And then at the Court of Appeals, remember, there was a request, Amy, when this case was granted review by the court to expedite the consideration, not wait for the last day. Court denied it. They sat out. They didn't want to go fast. They did not put it on a fast track, which is quite unusual. All the other cases that I've been involved, Pentagon Papers, Nixon tapes case, they all went on fast track. I mean, they decided those cases really, within weeks, if you will. Super fast track. Here, no, they did not do that at all. And so I don't think there's any way that this case is ever going to get tried before November.
Okay. I've got some comments and questions coming in. By the way, people who are adding comments and questions, thank you. Go ahead and do it on whatever platform that you're watching. The rant and rave box is over at bitshoot.com. Someone says it's a deep state coup. And I don't know if they think that this particular opinion is a deep state coup. Do you believe in the deep state anyway, Bruce?
No, I think I understand the statement, but deep state indicates that it's covert, it's secret, it's concealed. It's more frightening. This is all open and above board. We can all see it. I mean, when Donald Trump said, then I have the right under Article 2 to do anything I want as president, he's not concealing anything, right? It's all open above. When Joe Biden says, yeah, I can go to war anytime I feel like it, to protect a NATO member, to protect Taiwan. This is not secret about that. When James Clapper in the NSA says, yeah, we spy and we accept all of your information, what's secret about it? We know what's going on and still acquiesce. That's what's frightening. But in terms of the coup and overthrowing the rule of law, that's spot on.
Okay. And then someone named Valiant Thor leaves this comment. He says, this doesn't apply to Biden. He stole classified documents while he was a senator and vice president. This applies only if you're a sitting president. Is that right?
It's broader than that. Remember, Trump is not a sitting president.
Or maybe he means a sitting president when you committed the actions at issue. How about that?
Well, they addressed that. Now, of course, as a senator, you're entitled to what's called speech or debate immunity.
That's different, though,
in the Gravel
right?
case. Yeah. So Biden could be protected from criminal prosecution under that theory.
Not for stealing classified documents, though, correct?
Well, it depends upon how it was done. Is the evidence you couldn't use the fact that the documents were read into the congressional record or something as evidence of any criminality. I mean, Mike Gravel got the Pentagon Papers. He read them all into a congressional record, 47 volumes of top secret information. The Supreme Court said, no, you can't lay a hand on. So,
Wow.
and that's that. But at least in that case, Amy, there's explicit language in the Constitution of immunity for members of Congress. It related to efforts by the king to kick out and persecute any members of parliament who are haranguing the king, right? So they said, no, we wanted strength and we want to make Congress fearless in criticizing the executive. So they wrote these provisions in.
Fearless in speech, though, not in performing actions that are arguably criminal.
Yes. Well, yeah, but not just speech, but holding hearings, asking questions, issuing subpoenas, things of that sort, introducing legislation, introducing impeachment resolutions, things of that sort. Now, obviously, just engage in pure theft for the sake of theft. You can't go down to 7-Eleven and commit thievery and say, I'm a senator, I'm immune. No, that's not going to qualify for immunity. So the court, I believe, without any, in my judgment, justification whatsoever, decided that this level of immunity was required in order to protect, the executive branch from curtailment or fright. But think about that, Amy. We've had 234 years. There's never been any case ever that suggested a president had such immunity, right?
So then they would say that it's because there's never been any case ever in which a sitting president, Biden, was using the prosecutorial function to try to defeat someone, his opponent, running for re-election. Just, I'm playing devil's advocate here, right? They'll say this is an unprecedented case in that regard. And so it's the only time that the court has been asked to stand in this way.
Well, I think it's fair to say, Amy, you're correct. These are unique facts, for sure. Mm-hmm. Everything is unique. At the time the indictment was issued, Trump was not the nominee of the Republican Party. He still isn't. He might have been. It wasn't clear whether he was going to run against Biden.
They knew he probably would, though, right? Because, it's funny. He protested last week in the debate. Oh, I really didn't want to run. And I did not find that authentic at all. He wanted to be president again and it's evidenced by the actions that he took that are part of the allegations in this case, that he really wanted to hold on to the presidency. So they probably knew, even though it hadn't been official yet, that he was going to run, right?
Well, I think it's probably, we knew Trump has presidential ambitions, just he's narcissist. So I don't want to sound like I'm naive.
Right.
That even if he wasn't the nominee, he certainly was a possible contender, for sure. But of course, you have to get a grand jury to indict. Then you have to get a jury to convict. So it surely is true that it's always been possible for a president to kind of try to manipulate, if you will, the criminal justice system to attack his political opponents, right? We have 234 years, and this has never happened before, ever. So why do you think that it wasn't the nature of the acts that caused the indictment? Because you remember, this indictment is not in isolation, right? This is sitting with 3 other indictments in Georgia, in Florida. Florida grand jury is not like a DC grand jury. Mm-hmm. And in New York, where he's already been convicted of 34 felonies. So it doesn't look like, oh my God, they just kind of invented this case out of thin air. Nothing. There's really nothing there that could justify it. But it certainly is. It's always possible they could find a vindictive ulterior motive. But that's why we have a criminal justice system. Politics goes into decisions all of the time, because the nature of prosecutors who are oftentimes elected in deciding who to prosecute, because you got a limitless number of laws to enforce and you can't enforce them all. And the court has never, ever said, well, if politics infects, a decision to go after a defendant A as opposed to B, it's illegal unless you can prove that the decision was based upon the race or the religion of the defendant. So this is just part of the criminal justice system. And moreover, if I'm looking at, but let us assume, Amy, that there is this possibility, and I can't rule it out because in general, politicians are sociopaths and scoundrels. Okay, that there's a possibility that one president would use the power to faithfully execute law, even if it's invalid, to indict someone, even if it fails, because obviously it's very harrowing, it's very anxious. It creates damaging to your if you're indicted, even if you're not convicted. That's not something anybody wants. So there's a danger in abuse, for sure. That's been around for a long time, but maybe it's heightened if you're going after a former president.
Right.
Although I must say this, that there was no one, Amy, no one when I was there on the ground when Nixon left office who thought pursuing him criminally was a vendetta.
Sure.
This is he violated the law. His co-conspirators were sitting in prison. But we live in a different era than in Nixon's, for sure. But putting that aside, if you're trying to calculate the danger to the country, to the liberty, the rule of law, and the Constitution, the danger that a president with immunity will destroy the country, wipe out the rule of law under the theory that he's faithfully executing the law when he's sabotaging it, is so much greater than creating a fear of a president. Don't push the envelope too far. In my view, it's healthy to tell the president, don't push.
No, and I agree. So nobody please mistake the fact that I'm playing devil's advocate here as the fact that I'm not sympathetic, because again, government is supposed to be limited in the authority to act, because everything that it does involves force, and the Constitution is meant to constrain the acts of government. So this whole idea of presumptive immunity when there is not a clearly described official action that the president is performing is completely against that principle of limited government that's supposed to act only with permission, right?
Yeah, and moreover, Amy, just add another thing. It's completely atextual, as the court likes to say. That is, when the framers thought about immunity, they gave it to the members of Congress in performing official duties, legislative duties. They did not give it. It's very conspicuous. Read the Constitution. It's very short, 7 articles. They did not give it to judges. And judges can be prosecuted and have been prosecuted while they're sitting on the bench for judicial acts like taking money in exchange for issuing a certain ruling, And we know that the executive branch is not given any immunity under Article 2. And the drafters knew how to grant immunity because they did it in Article 1. So there's a strong inference you don't have immunity if you're not in Article 1, because they withhold the same language from Article 2 and 3. And judges, for sure, have been prosecuted. Fortunately, we don't have a whole lot of judges who are corrupt, but there have at least been a half dozen or more who've been prosecuted for acts on the bench. So why should the executive branch? Why are you making up something that's not there? Especially when you keep focusing on textualism.
Okay, so someone in the comments here is making a distinction between the president himself versus the executive branch generally, and I think by noting the fact that presidents can serve for only between 4 and 8 years, 8 years at most, that there's term limits, that I guess there is a limitation on the amount of damage a president could do were you to award him this sort of immunity. What do you say to that?
Well, first of all, the 2-term limit didn't come into play until after like 160 years of the Constitution. So those who were drafting the Constitution did not have in mind any 2-term limit, right?
Okay.
And moreover, given the power of the president and the size of the military and weapons and violence, you don't need 8 years to destroy the country. Adolf Hitler only needed a few days to burn down the Reichstag and to dissolve the Weimar Parliament at the time, the Reichstag. So it gives somebody 8 years with that limitless power over a multi-trillion-dollar military-industrial complex and surveillance of every single thing that moves, on the planet. You could destroy the country far faster than 8 years.
I guess he's pointing out the 4 years of a stretch or something that somehow facing an election is going to change things. But I would say to feral robot is what this person calls him or herself, that many people are afraid right now that a sitting president can make it so that there's not going to be an election, a proper election in the next term. Certainly in 4 years, there is a lot of damage that can be done. I'm going to go to a comment that was submitted. Actually, it's just some quotations from Jeffrey. Clarence Thomas, I guess Clarence Thomas filed a concurrence. Is that correct, Bruce, that he's quoting
right.
from that?
I have to concede. I've just looked at a sentence or two.
Yeah. So here's a quotation, and I'll read it slowly since, again, you've got this huge swath of papers thrown at you and says, okay, talk on it now. He says, this is Thomas. He says, if this unprecedented prosecution is to proceed, it must be conducted by someone duly authorized to do so by the American people. End quote. What do you say to that?
Well, under that theory, if you think it only be prosecuted by the president, then we won't have any prosecutions at all. He's going to be the one who's elected, and he's going to go before the grand jury and be the trial lawyer. It's a ridiculous claim. Moreover, that argument was made years ago in a case called Morrison against Olson, when Congress had created an independent counsel appointed by 3 judges to prosecute cases in which the executive branch had a conflict of interest because one of their own was a target or a high-level official in a political party. And the court voted with Chief Justice William Rehnquist, an appointee of Richard Nixon, very conservative, saying no, that these independent counsels are inferior officers. They do not need confirmation by the Senate. So that this insinuation that because Jack Smith, the prosecutor, has not been confirmed by the Senate, hey, that doesn't pass muster, is just wrong, unless he wants to overrule Morrison and Olson, although I must say with
maybe he does, right? Maybe he does.
Justice Thomas likes to overrule virtually the last 200 years of jurisprudence. He's willing
I would like to overrule a whole lot, let's go back and bring Lochner, et cetera.
No, these are important questions though, Amy, your observation. And that is the reason why there's a reluctance to overrule isn't because there's any virtue in preserving laws or decisions that were wrongly decided. It's that there needs to be some level of predictability in the law. And as a person trying to plan their behavior that conforms with the law, and as an attorney trying to give advice to counsel, if I think every single decision is up for grabs, you can't rely upon anything, that you can go into court and re-argue the last 3,000 cases that have been decided by the Supreme Court, the system of law would break down, completely break down. And there is a remedy, and it's not an easy one. That is, when you think the court has it wrong, either because they misinterpreted a statute, Congress can correct it. The Liddy-Ledbetter Act corrected what the legislators thought was an incorrect interpretation of civil rights laws in other instances. Or if it's a constitutional decision, you can amend the Constitution, like was done to overcome Dred Scott v. Sanford decision saying income tax laws are unconstitutional. So there are ways to get around bad Supreme Court decisions. That's not ideal, but the opposite, saying stare decisis out the window, everything is open all over again for anything, the fabric of the law would crumble.
Would you modify that statement, which is pretty broad, when the overturning of an old precedent would result in more liberty for the people? So of course I go back to my old favorite pet examples, the Smith and Miller cases from the 1970s, which says, the government can obtain without a warrant information that you share with third parties, such as telephone companies and banks. If those cases were to be overturned, which is one of my dreams, then we would have a lot more privacy vis-a-vis government. We would be able to maintain, obtain, protect states of privacy for ourselves using our rights to property and contract in ways that we just can't do right now. So it would be more liberty for us, more enjoyment of freedom and privacy for us. Would you say that in those cases, it's not as damaging if we overturn Supreme Court precedent, or it's kind of on a par? It's the same. You should say, let's amend the Constitution.
Well, again, it's a matter of balance and degree, Amy. And I have a conflict of interest because I asked the Supreme Court to overrule Smith versus Maryland and the Miller case. I provided certiorari this, and I told them this is ridiculous. It's bad. So I'm on record as saying, yes, some cases should be overruled. But there ought to be standards that are a higher threshold than, hey, we think you got it wrong. Now, I'm not certain what they ought to be, but it's a balancing test. You can't just, and the difficulty that we have at present is that the Supreme Court has never articulated anything more than a standard of, I know it when I see it, and this needs to be overruled. That's basically what it is. They just overrule or don't overrule, but there's no way a litigant could be confident at all. Well, this particular precedent satisfies the standard for overruling. I'll make this case to the U.S. Supreme Court. They do what they want to, which again makes it a lawless court. But putting all that aside, I want to continue to repeat, Amy, despite you'll see, obviously I'm very critical of what the court did. The judicial branch still is heads and shoulders above the other two when it comes to any semblance of justice or fairness. As wrong as I think this was, hey, that's the decision. You can go back, ask it to overrule it, or you can amend the Constitution or something like that. We cannot disobey the decision and say this is just wrong and heck with it. No, we're going to end up with a law of the jungle at that point. Solitary, brutish, nasty, and poor. So that's what I think is very important. And that's why I think also when you remember Dred Scott, the decision in which the court said that the black man has no rights that a white man is bound to respect, in upholding and prohibiting Congress from confining or excluding slavery from the territories. Abe Lincoln said we still have to obey the court, as bad as it is. And what was the response? The response wasn't just to say, the heck with Dred Scott. They amended the Constitution. The 14th Amendment, Section 1, specifically amends Dred Scott. Right. You are a citizen, you're entitled to rights if you're born in the United States and subject to the jurisdiction thereof. Which is, again, process is so important. I know there's a tendency, if you just asked me right now, I said, wow, this is such a bad decision. We got to stick with it, with the process. As bad as it is, because the alternatives, the cure is worse than the disease. And that's what's very important to understand.
Let me read to you a quote from the Sotomayor dissent. Again, thanks, Jeffrey, for sending this one. Quote, looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new Officials Act immunity now, quote, lies about like a loaded weapon, end quote, for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation, end quote. I presume that in that situation, you actually agree with Sotomayor, which maybe isn't a frequent occurrence, yes?
Spot on.
Yeah.
This is the equivalent, Amy, of the king can do no wrong, which was the fundamental doctrine of the British common law, which in part provoked the American Revolution. And now we have our own version of the king can do no wrong. Appalling.
Yeah. Another comment that Jeffrey submits of his own, which I assume is a bit of an answer to my devil's advocate playing earlier. He says it is an unprecedented prosecution because it is an unprecedented act and unprecedented behavior that's being prosecuted is the implication there. So you agree with that as well?
That's why I say, of course, it's sui generis. It never happened before. We couldn't even conceive. I mean, virtually everything in the Trump administration was sui generis. I mean, I'm not saying that it was totally different than Johnson or Nixon predecessors. Listen, I'm not a fan of presidential authority. They've been abusing authority for a long time. But Trump took a logarithmic leap and said, as I say, I can do anything I want as president. And he did. Okay, you're not going to vote funds for me to build a wall with Mexico? I'll just use military construction funds. Doesn't matter. No, if Zelensky says he's not going to investigate, Joe Biden, okay, then I'm not going to give him the weapons that Congress appropriated to send over to Ukraine. And remember, John Bolton. John Bolton's a lawyer. I knew John when he was at the Justice Department, the Civil Division. John Bolton, his national security advisor, writes a book and says obstruction of justice was a way of life at the White House. A way of life. Listen, Nixon did bad things, but it was never a, quote, way of life at the White House. And John Bolton was an appointee of Donald Trump. Very, 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 very conservative. It's hard to find somebody more conservative than John Bolton.
I had an argument with him, by the way, right after the Snowden revelations. Yeah. I was able to interview him. And, whereas many things I agreed with Bolton at the time, I strongly disagreed with what he was saying at the time, which was that, Snowden should be tried, convicted of treason and hung, et cetera. So that was interesting. But no, I mean, if he says it's a way of life, chances are at the very least that there was a lot that we would raise our eyebrows at. And one of the problems is that, all of this presumptive immunity can be applied equally to whatever is going wrong in the Biden administration, right? Yeah. So, anyone who's saying, oh, this is, this is good because Trump gets all this immunity, every president going forward gets it as well, including Biden.
Yeah, well, I mean, Trump has already said that Biden has committed more crimes than any other president. He's going to prosecute him. Well, now, okay, you're hoisted on your own petard. Yeah. Now he has the same immunity that you have. But it's a disaster for the country. I don't have any sympathy with shielding Joe Biden from prosecution either. I've drafted articles of impeachment because I think he's done illegal wars all over the place, and violating federal laws, limiting, what he's shipping weapons and making us a co-belligerent without any declaration of war. I've never voted for Joe Biden. I've never voted for Donald Trump. I'd never vote for either of them ever. Over my dead body, I'd write in James Madison or George Washington or something like that. It's not a partisan issue. It is a disaster for the country.
Right.
We now basically have a king can do no wrong doctrine ratified by the United States Supreme Court. That, for somebody who was born in Arlington, Massachusetts, and grew up Old North Bridge, by the bridge that arched the flood, their flags to April's breeze unfurled, here once the embattled farmer stood and fired the shot heard around the world, Lexington and Concord, we now have a king? Shocking.
Not what you would have thought at all. We have just a few minutes before we're the top of the hour, and I want to not keep you too long. I want to ask you, though, a little bit about the net choice, the Moody versus net choice ruling. As I scanned the syllabus, they, in effect, again, remanded to the district court, just like they did with this case, telling the court that you need to conduct more factual findings, not just about what would happen with YouTube or Facebook, the top 2 established services feeds, but with respect to all sorts of services generally, that in essence, there wasn't a rich enough factual record created below. Did you make anything in particular of that ruling, or you just say it is what essentially I said it is, and we just wait and see?
I think the ruling was more fulsome than perhaps you had time to elaborate.
Okay, good. Good.
because the court said in remand, they basically said these statutes are flagrantly unconstitutional as applied to a certain category of targets. But since your complaint was a facial attack on the statute as applied to any media at any time, therefore, in order to make a case for a facial attack, you have to show that it would be unconstitutional in virtually every single application. And you haven't developed the record enough. But I do think, Amy, the writing is on the wall. In Justice Kagan wrote the opinion. She said these are unconstitutional as can be, as applied to some categories of coverage of the statutes. But since you attack coverage to everybody, then you have to have a stronger factual record before we can strike out the statutes on their face. But I think it's fair to say the social media companies won as a practical matter.
Yeah, and I mean, it is the big platforms, Facebook, YouTube, et cetera, that Florida and Texas would be most concerned to apply the statute to in the first place. So if that's been invalidated, then
or they'd have to amend their complaint. And maybe what will happen is they'll amend their complaint, ask leave to amend it and just say as applied, and then they'll start running victory laps. But so when the court, because the court went out of its way to give guidance on it, didn't say we just remand and otherwise.
No. It gave guidance as well, just as it did in the Trump case, right?
Yeah, but more than just little guidance, Amy. Both Trump and the case you referred to, they're 100 pages long. It's not a little guidance.
No, it's extensive guidance.
Yeah.
It's
a very detailed roadmap.
So whereas. So in the Trump case, you say essentially it is very bad news for the scope of the executive branch power. It gives the executive, it gives the president in particular free reign in a way that he shouldn't have been given. So that's very bad news. But the Net Choice versus Moody, again, it is a remand, but you think that bodes very well for our rights to free expression. Yes.
Well, I mean, the answer to my mind, Amy, is yes and no, because I've thought at a certain stage, the social media behemoths become the equivalent of an electronic public square.
Oh, right. You have that view. Yes.
And so the Marsh versus Alabama standard. Mm-hmm. And if they're electronic public square, then it seems to me that they serve the same role in our democratic dispensation as streets and parks in the old days. And in streets and parks, you could regulate time, place, and manner if you had demonstrations, but you couldn't be viewpoint prejudiced.
Correct.
So if you open the park up for a demonstration for Republicans, then you have to give it for Democrats. Or you open it up for the Klan, you have to give it to the NAACP, things like that sort. So the government have to be viewpoint neutral on that score if it's performing a government function. And I think that there's a strong case to be made that these social media platforms are so big and huge that they should be treated as Marston, Alabama, the company town was. And you can have reasonable time, place, and manner limits, including prohibiting any posting that's illegal, defamatory, because that's a reasonable limitation matter, because you don't want to offer your own assets to commit illegal acts. But otherwise, do not permit it to censor one or another. Now, I'm hesitant to that, Amy, only because I've lived long enough to know that what looks like a social media behemoth today may be an acorn tomorrow, because technology moves at warp speed. Every year that lapses, it goes so fast I can't come close to keeping up with it. And so there may well be alternate forms, and their dominance of the idea market may dwindle. And so this is not something that's necessary. You just have enough outlets that you don't need to impose that kind of content restriction, because there's so many other ways and access you have to different ideas. It's the same way where at one time, Amy, newspapers were kind of the monopoly in local area. That's a long time ago, but now who cares? In newspaper, they write whatever they want. There's no censorship, and you got 50,000 other places to look for information if you're dissatisfied with your newspaper. So that's
But
the
they
implication.
would not have told, the court would not have ever told a newspaper, even if it was, enjoying a monopoly within a particular area, they wouldn't have told a newspaper how it would have to select its opinion pieces or how it would have to conduct its reporting, et cetera. That would have violated the First Amendment, yes?
Yeah, in fact, that a case came up called more Miami Herald versus Tornillo, and the court said no, we can't do that. They have to edit
Right.
their own issue. But that's 1974. It could have changed if they were super monopolies. But that I don't know. When I came to Washington, there was many. Washington Post wasn't really the only real newspaper here. You had many other newspapers that flourished, and in New York, you had 6 or 7. Now you're down to only a handful. So there was never that, I think, scope of monopoly power anyway in the newspaper industry. But putting that aside, I'm very skeptical of the government trying to impose its views. But it's one thing simply to say that you can't discriminate on viewpoint. So that means you open up to everybody. You're not favoring Republicans or Democrats, conservatives or liberals. Just say viewpoint neutral. You just have a platform. It's like a
I understand. But so what I always hesitate with is anytime you allow a statute like this to stand, you are creating a further entanglement between government at any level, and social media. And social media platforms are the way that so many people get their information, they share information, it's all disseminated. And plus, of course, they collect a lot of personal information about people. And I don't want to give any government any more levers that they can use to threaten or manipulate social media platforms than they already have. And I would prefer to deal with any of this, the censorship that occurs if it's biased and et cetera, through the removal of the presumptive immunity under Section 230, right?
well, I'm
So
in favor of that, but I think
that's the way I would deal with it versus
but I don't think
limit the
I
comment
think
periods.
if you limit it to time, place, and manner, you can't manipulate because we've had time, place, and manner rules for parks and streets and sidewalks and whatever for years. Government was never able to manipulate it, so you could only march if you were in favor of George Floyd but not against or whatever. You couldn't do that because you can't have viewpoint as a foundation for granting or denying the opportunity to demonstrate. And think of this analogy, but all analogies are not perfect. The telephone company. Do I find it would I want the government to be able to tell a telephone company you're supposed to do XYZ? Telephone company, that telephone company could say I don't want to serve you because you're a Republican or a Democrat or you believe in transgender surgery. You don't. I mean, you'd say no. I don't have a problem in telling telephone company you can't decide to withhold your services because you don't like the political viewpoints of a subscriber. That seems to me wrong. Um, and I'm not sure how you could distinguish that situation from a social media
So go
company.
ahead and force people to bake the cakes, in other words. Yeah.
Yeah.
Okay. Well, that'll
Again, because
be a debate we'll have to have on another day, right? Because I
yeah,
don't think you should force anybody to bake anybody else's cake. That's the way I always put that question. But yeah.
but then you don't have to be in the business of baking cakes. And Amy, you got to think about this too. You should people be in the business of telling what kind of employees you hire? Well, for a long time, if you're black, you couldn't get hired, or you could Irish, you couldn't get hired in Boston.
Mm-hmm.
We have civil rights laws, and for some time, you're being a woman. Hey, we're not going to hire you because you're a woman. Say, well,
I know.
you don't want to have, and the government's telling them, your hiring decision is not yours alone. There's certain things you can't do.
I know the government does this. I know that there's precedent for this, but I still disagree with it. That's where I'm at. So we'll have a spar.
Amy, as a woman, you think that it would be you would be angry if the government said you can't refuse to hire me just because I'm a woman? Amy, you're entitled to be treated because of who you are, not what your gender is. Why did I objected? I mean, that's something that can be readily applied. It's not like you can subterfuge the issue. And we've had that law around, for like 60 some years. I don't know whether it's, government manipulates it, to try to get a certain percentage of women or men in some particular areas. My observation is this, Amy. I know we all like to look and see prime colors in the world. But in reality, the more accurate description is chiaroscuro. It's gray. It's blend. We got to use our mind. There's stopping points for everything. And that's why we have brains, to know where to draw the line, even if it's not precise, like the circumference of a circle. It's pretty good. And you got to do that, because life isn't that easy. It's complex. It's what H.L. Mencken said. To every complex problem, there's a simple answer, but it's wrong.
So I would agree on moral grounds with so much of what you're saying, but then whether government should enforce these restrictions is a different question. So, and this will probably be deferred to a discussion someday of anarchy versus limited government as well. And can you draw lines limiting government in a way so that it doesn't become more onerous and start to employ the sorts of things that you have suggested here, making certain people common carriers, prohibiting certain types of discrimination for groups, etc. Can you have a limited government based on objective principles that doesn't tell people how to run their businesses, doesn't tell people that they have to bake other people's cake? That's an interesting question, huh? But there's no way we'll get to that one today.
No, that's for another session, but it was some we should return to. It's very, very important.
I think so. And we probably will over the months. So I think now there's at least going to be a week off for you, Bruce, a well-deserved week, maybe more. We'll tell everybody when we're going to have our next episode. But thank you so much for being here day after day after day and commenting on these opinions as they've been released. I really appreciate it.
Oh, yeah, and it can't miss. Always applaud the viewers, those who attend. Good. You're engaged no matter what. There's no bad engagement. There's no bad questions, no bad observations. It's a team effort. That's how collectives operate to keep democracy on the right path. We can't just be docile and be spectators on the scene. So I congratulate everybody for spending the time to be an active participant.
I do as well. Thank you very much.
Okay. Bye-bye.
Take care, everyone.